Good morning, good afternoon, everyone. It's 2:00, it's 1:00, and we're starting right away. Good morning, good afternoon, everyone, depending on where you're joining us from. A very warm welcome to you all. I welcome specially the Chair, Chartered Institute of Arbitrators, UK, Nigeria branch, Mrs. Shola Adegbomire, the Chair, Corporate and In-House Council Committee, Dr. Nike Eson, our speakers, moderator, Leonard Silks, seniors, colleagues, and distinguished ladies and gentlemen, all protocols duly respected. My name is Justina Lewa, and I am the Vice Chair of the Corporate and In-House Committee of the Chartered Institute of Arbitrators, Nigeria branch. I am excited to be coordinating this webinar titled How to Lose $1 Million Arbitration Even Before It Starts. Lessons from Cases That Went Wrong. The webinar is being hosted by the Corporate and In-House Council Committee of the Chartered Institute of Arbitrators, Nigeria branch. Ladies and gentlemen, many companies and parties have lost billions in arbitration. This afternoon, our stellar panel, who have collectively handled over $1 billion in disputes across various sectors, will talk about how that happens and how to avoid costly mistakes. I will now proceed in a particular manner to introduce our speakers. I'll start with Mrs. Funke Adekoya, SAN. Mrs. Adekoya is one of Nigeria's most distinguished arbitration practitioners with over 50 years, no mean feat, of legal experience. She is a founding partner and former head of dispute resolution at ALEX and now runs an independent arbitration practice. Please, let's welcome Mrs. Funke Adekoya with virtual claps. Ma'am, you are welcome to this webinar. Next, I will introduce Professor Ike Iheribe, FCIAB, FAIADR, is a chartered arbitrator, international arbitrator, adjudicator, and accredited mediator. He has served as sole arbitrator, tribunal chair, co-arbitrator, mediator, expert determiner, and counsel in complex disputes. Professor Iheribe brings to today's discussion a rare perspective shaped not just by academia, but by sitting on tribunals and navigating complex, high-value disputes across jurisdictions. Please, let's welcome him with a virtual clap. Next is Dr. Babatunde Ajibade, SAN, FCIAP, managing partner of SPA Ajibade & Co., a leading dispute resolution specialist. Dr. Ajibade has extensive experience in commercial litigation and international arbitration, acting both as counsel and arbitrator. At today's webinar, Dr. Ajibade will share a counsel and arbitrator perspective on how strategic choices and case preparation can make or break an arbitration long before the final hearing. Please, let's welcome him with a virtual clap. I move on to Mr. Sheson Shobowale. Mr. Shobowale is the principal partner at Levante Solicitors, a boutique commercial law and regulatory governance advisory firm. Before founding Levante, he was head of legal services and general counsel at Union Bank of Nigeria PLC from 2017. And with over 30 years experience, he has led legal and corporate functions across FMCG, telecoms, banking and financial services, including as Company Secretary, Legal Advisor, and Corporate Relations Director at Guinness Nigeria PLC. Mr. Shoboale brings the critical in-house and business user perspective. He will help us examine how legal terms can avoid costly dispute resolution mistakes and ensure that a legal victory actually delivers a meaningful commercial outcome. Please, let's welcome him with a virtual clap. Next is our moderator for today, Mr. Harold Uku. Harold has over 12 years experience in dispute resolution, corporate and commercial practice, and in-house legal work in financial services. He currently serves as Assistant Manager, Legal and Corporate Services at First Trust Mortgage Bank PLC, where he leads the bank's dispute resolution portfolio. An associate member of the Institute of Chartered Mediators and Conciliators and a notary public of Nigeria, Harold will draw on this experience to guide our panel, ask the questions that matter, and draw out practical lessons for all of us. Please, let's welcome our moderator with a virtual clap. Now we have ground rules so that everyone would enjoy and listen without disruptions. So the first is our mics should all be muted, and we should stay muted until we are recognized to speak. And to be recognized to speak, please raise your virtual hand. There will be a question and answer time. Please do not disrupt the speakers while talking. Drop your questions in the chat box. The moderator will pick the questions there. There will be poll questions during the webinar. Please respond as soon as they pop up. Thank you very much for listening. I now have the pleasure of handing over to my amiable chair, Dr. Nike Esson, for her welcome remarks.
Good afternoon, distinguished speakers, colleagues, and participants. On behalf of the Corporate and In-House Counsel Committee, I also warmly welcome you to today's webinar, How to Lose $1 Million Arbitration Even Before It Starts. By way of introduction, the committee, for some of you that are joining us for the first time, was created as a platform where in-house, that is working in companies, in institutions, in government agencies as lawyers, where in-house counsel and arbitration practitioners and other stakeholders can have practical conversations about the issues that matter most in managing dispute and protecting businesses. And today's topic, today's webinar is just one of the many webinars that we have been, we've been hosting. And today the webinar is such that it's something that what we're going to take away are not things that you will find in any textbook. And they are very relevant to how we manage disputes. Yes, we can have a very strong legal case and still lose. We want to draw on the experience and the expertise of our stellar speakers. They have real life stories, practical lessons, which they are going to, share with us today, which at the end of the day, we'll be glad that we are here today and we are going to learn so much. So I encourage you to participate actively, share your own perspective through your questions, through comments, and then, the questions you may want to put in the chat box, and also to participate through the polls and also ask questions, share your comments and listen attentively. And certainly, like I said, you'll be glad that you participated in this webinar. Again, I'll say thank you for joining us and welcome, and let's the show begin. So, thank you very much. Over to you, Harold.
Okay, thank you very much, Madam Chair. Good afternoon, distinguished panelists. Good afternoon, audience. Thank you to the Chartered Institute of Arbitrators for putting this together. It promises to be an interesting session. It's a privilege for me to moderate this session. So without wasting much time, we'll be we'll be beginning this conversation, how to lose $1 million arbitration before it even starts. My hope is that at the end of this session, we would learn how not to lose $1 million arbitration before it starts. So let us begin. Let's begin from Dr. Ajibade, sir. Let's start with a big question. How does $1 million arbitration actually get lost before the hearing even begins? Please, we would love to hear from you, sir.
Thank you very much, Harold, and good afternoon, good morning, good evening, distinguished colleagues, attendees. First, let me thank the Chartered Institute for inviting me to participate in this very interesting and important conversation. This question is a key one. I guess it sets the stage for a lot of the interesting things that we're going to discuss going forward. And I think it's critical. There's a tendency in looking at the question to look at it just from one side, perhaps from the claimant side. But my view is that this applies equally to both claim as well as defense, because whether you're a claimant or a defendant, if you are the defendant to a multi-million-dollar arbitration, you also want to make sure that you don't lose it even before you get to the hearing. Ditto, if you're a claimant, you want to make sure that your claim doesn't fall flat on its face before the hearing. And for me, the first and perhaps overarching challenge for anybody involved in this kind of dispute is the importance of attention to detail. In my experience, where you tend to find that challenges have arisen is when the litigants, counsel, both in-house and external, have not paid sufficient attention to detail. And that affects really every aspect of preparation of a claim or preparation of a defense. And as I said, the detail of this, I think, will come out as we address some of the other questions that we'll be looking at. The second is assumptions. There's this popular saying about assume means making an ass of you and me. And I think it tends to become apparent in matters like this. When you assume things, you can't afford to take anything for granted. Either assume something about the strength of your case or the weakness of the other side's case. You really need to, in high stakes disputes, when we're talking about $1 million arbitrations, you really need to make sure you don't leave any stone unturned. Don't leave any document unreviewed. Don't assume that this is not relevant. This is just a bunch of paper. I don't need to read this. You really need to pay attention to every single item. The other problem that I've seen occur often that causes parties to lose is when they focus on one aspect of a claim and ignore the other. Typically, the litigant and counsel, corporate counsel, who feels that they have a very good claim might focus on liability, forgetting that even when liability is established, quantum is not automatic. So if you focus on establishing liability, but you haven't paid sufficient attention to what exactly are you going to get after having established liability, and it's too late to start scrambling midway through the hearing to put your evidence in support of your damages together, that's something that you need to have done well in advance. The other thing, again, a general observation is failure to identify what are the critical building blocks of your case. We often hear talk of having a case strategy. And if you have a case strategy, you'll be able to identify what are the critical building blocks of that case. It might be the evidence of a particular witness. It might be a particular document that has to be in evidence. It may be that it's a document that you don't have, but you know exists. So you need to work out carefully your strategy as to how you're going to extract that document, either through discovery or interrogatories or whatever other methodology may be available to you. And lastly, and this is by no means exhaustive, but I know the distinguished panelists will go into this in a lot more detail. Lastly is a failure to consider where the assets are that you are disputing over. Because again, you establish liability, you even get a good award. But then if you've obtained an award and the assets are in a jurisdiction where you can't actually enforce, or the assets are liable to have been spirited away even before you get to your award, then you might end up with a Pyrrhic victory. So these are some of the issues really that I think that counsel, corporate counsel, in-house counsel, and external counsel and litigants need to be aware of, so they don't lose the battle even before they get to the battlefield.
Thank you very much, Leonard Silk. You have indeed set the stage for this conversation. Attention to detail, assumption, focus on the important aspects of the case and not ignore any aspects, and case strategy. Thank you very much, Leonard Silk. Professor Hiribe, let's start from your own experience in your international arbitration career. Have you encountered a case where you immediately felt that this case may already be in trouble? What gave it away?
Thank you, Mr. Moderator, but I hope you can all hear me clearly.
Yes, sir, we can hear you, sir.
Very well. Before I respond, I think there's some housekeeping I have to embark upon, which is to, again, first stand on all protocols, but to expressly thank the Nigerian branch of the Chartered Institute of Arbitrators for inviting me to participate in this august gathering and august discussions, in particular the chairperson, Mrs. Adebomire, and of course, the quaint corporate and in-house council committee for putting all of this together and bringing me, also allowing me to participate. I thank you all immensely for this opportunity and the sterling work you're all doing to propagate the use and benefit of arbitration in high-ticket cases. And please, I want to at this juncture preface the comments I'm going to make in contribution to what Dr. Ajibade has articulated so far with his usual expertise. First, my comments are from the point of view of a tribunal member, i.e. as a sole arbitrator or co-arbitrator or chairman of tribunal. I just want that to be clear from the onset. The second point I want to draw to your attention now that I have the floor before I forget is to crave indulgence of the organizers and the conveners of this event to tweak the title a bit. And I think Dr. Ajibade alluded to it in passing. But being the diplomat that he is, he went about it in a very academic manner. I want to hit the nail on the head and invite the conveners to next time consider rewarding the title to, first, how to resolve $1 billion arbitration before it even starts. Lessons from cases that went wrong or went right, so that everyone feels included, both claimants and defendants, in any $1 million. Of course, I don't know what $1 million looks like, but that's the expression used. I would prefer to use a high ticket or complex disputes, so that some people won't go away with the wrong impression that all disputes are all about million and billion dollar amounts of money, because those amounts of money scare me for various reasons that will become more apparent later on. So if we can just tweak the title a bit next time, how to resolve complex disputes before it even starts, lessons from cases that went wrong or cases that went well. Everyone will have a buy-in. Those who have lost a lot of cases in the past, and those who want to learn from those who are going to win in future. So those are my introductory comments, and please, if I'm getting out of time, forgive me. Now, to add to, first and foremost, I endorse all the points that Dr. Ajibade has made. and he couldn't have put it any better. But something else, a lot of other things that I find missing is not in the textbooks. Is a complete failure by counsel in particular to understand the dynamics going on in the arbitration spectrum. Now, if you hack back to the unsocial model law, that's the overarching instrument that enjoins and encourages the international resolution of complex disputes, what the model law talks about is resolving cases, not whether you win or lose. Win, lose is litigation language. But see, for the arbitral tribunal, they are concerned primarily on how to resolve the disputes, as complex as it may be, in a cost and time efficient manner. And that phraseology is borrowed from the model law. And I can appreciate that counsel, be they in-house counsel or external counsel, will approach the dispute from how do we win? How do we win this case? How do we ensure we don't lose? That's fine. That's what makes the clients happy. But for the tribunal members, for the experienced tribunal members, they are focusing on how best to resolve that dispute vis-a-vis the pleadings, the claims, counterclaims, submissions, and the evidence in a cost and time efficient manner. So, and most of the time, what I find is that counsel who have come to the arbitration space with a litigation culture are already working their way towards potential loss. Because depending on who the tribunal members are, you're going to find, and if adequate attention is not paid to one, who the tribunal members are, two, who is presenting the case before the tribunal members, there are going to be challenges and tension that potentially leads down towards, if not total loss, but partial loss of the arbitration. And when I talk about partial loss, and just as Dr. Chibade alluded to, failure to engage in the actual merits of the claimant's case, what is the strategy to ensure that if potential objections are thrown into the mix, as most defenders are wont to do, what is our defense? How do we counter those defense mechanisms, i.e., the quintessential jurisdictional challenge? What if there are orders for disclosure? What are the orders for inspection? What do we do? Yes, we have a watertight case on the face of it, but what is our defense? What is our response if the defense comes up with these other strategies that might derail that so-called watertight claimant's case? Now, remember, as I've always said at my various lectures, that a party, a commercial entity that invokes the arbitration process is embarking on a commercial endeavor. Why do I say that? If it's an ICC case, for instance, before a claimant initiates that action, that claimant is paying first and foremost the equivalent of 3,000 euros or more first to initiate the process. That claimant wants to make sure that if that case succeeds, he gets the damages required and the costs associated with the tribunal or the arbitration, and indeed all those payments made out. So these are things that have to be thought through by counsel appearing before the tribunal, ensuring that they can get the best out of that tribunal, ensuring that who is presenting for that tribunal understands the dynamics of the tribunal members and how they can get the best for overall success of the claimants. So I find a lot of times that those are not paid adequate attention to, and you now find that that strategy falls apart when the counsel thought they were going to the Supreme Court, or they thought they were going to the House of Lords, when the House of Lords used to exist. And that, for me, is the wrongest of strategies, which contributes one way or the other to loss or a partial loss. Thank you very much.
All right. Thank you very much, Haichi. And thank you for the intervention with the topic. We have taken the hint. I'm sure the organizers will set up something else that will continue the conversation.
Just a suggestion, no?
Thank you. Thank you. Mrs. Adekoyama, when you were introduced as having over 50 years of practice experience. And I know that you are an independent arbitrator. You now focus majorly on arbitration. So you would have a lot of war stories. You would want to hear one of those war stories. What is the most expensive arbitration mistake you have ever seen, and what could have been done differently?
Thank you very much. Starting with the Chartered Institute and the committee for this invitation to participate. I'm so happy to be here. I assume that by the time we are done, we would not just share knowledge, but we would have learned from each other. For me, I will kick off from 2 points or 2 statements that have been made by the previous speakers. Dr. Ajibade talked of assumptions, and he said you assume, and defined assume as making an ass of you and me. And High Chief Iheribe spoke about a failure to understand. In his context, he spoke about the failure to understand the dynamics of the case and the dynamics of the tribunal. But my war story is going to talk about making an ass of you and me, by which I mean making an ass of the tribunal and the counsel who was presenting by failing to understand the case that was put forward. Thankfully, it's not a Nigerian case. It involved a foreign country and a foreign investor. The foreign investor said, I'm bringing my claim under a bilateral investment treaty, and I'm claiming damages. It wasn't in the billions, but it was in the hundreds of millions. I'm claiming damages from this particular period. I think it was like 1983 or 1993, when I invested in the country and provided all the evidence. The respondent, in answering, said, we were only involved, the respondent is the respondent state, which eventually bought a stake into the business. And the respondent's defense was, we only became involved with your investment 10 years after, when we decided to do public-private sector partnership and bought into your investment. And therefore, whereas the claimant calculated damages for a period of about 20 years, the respondent said, if I am liable at all, which I deny, my damages are only from when I actually got involved in your business, which was probably like 15 years down the line. So the respondents just calculated for maybe like 5 or 7 years. And the difference in the amount that the respondent was talking about as what the claimant should be claiming, which it disputed, was about $80 or $85 million. Because the respondent did not understand the case that was being put forward, the basis upon which both parties were calculating their damages were totally different. At the end of the day, the tribunal found for the claimant because it had proved its case, it had proved its loss, it had proved its damage. The respondent did not answer to the damages from the date of the investment. It only answered to damages from the date it became involved in the commercial enterprise. And for me, I take that as how to lose $1 billion claim before you even start. Because if you didn't understand the case that was being put forward to you, then you really can't defend it, which was exactly what happened. So that's my war story.
Thank you very much, Ma. Thank you very much, Ma. That was a very insightful one, a very practical one. Mr. Shobowale, let me move to you. You have a vast experience. I mean, given your in-house background, you were former general counsel of Union Bank, and you are now into private practice. In your experience, are arbitrations most often lost because of weak legal arguments or avoidable mistakes made much earlier? You're muted, sir. Please, you can unmute your mic, sir.
Yeah, thank you very much, Harold. Good afternoon, fellow panelists. Thank you for having me here today. I'm excited at the conversation that we're having. And I'll just like to start by saying that first, I haven't seen a definitive data on the issue, but anecdotal evidence and certainly my own experience suggests that arbitration is most often lost because of avoidable mistakes made before the proceedings actually commence, rather than weak legal arguments that are presented to the tribunal. So, and these range from schoolboy errors in drafting the arbitration agreement, poor arbitrator selection, poor document control, including failure by the parties to preserve evidence, and poor corporate document management practices of the parties. I think that for any party who asks or anticipates that disputes may arise from contractual commercial relationships, these are things that they should pay attention to, even if eventually no dispute arises. Thank you.
Okay, thank you very much, sir. Thank you very much, sir. That was quite brief. So since you mentioned, one of the things you mentioned was poor drafting and the preliminary documentation. Mrs. Adekoya, I would come back to you, ma. We observe that parties usually love multi-tier dispute clauses. They would want to move from negotiation to mediation and then to arbitration. How often does a party's failure to strictly follow the steps in the arbitration clause, how does it delay the entire arbitration much later?
Another war story.
Thank you.
And not just does it delay the resolution process, it actually can increase the cost. In a particular matter, parties went to, claimant filed for arbitration, respondents responded and challenged my appointment and said I had not been validly appointed because the dispute resolution process had not been concluded. There was supposed to be negotiation, then there was supposed to be mediation, and then there was supposed to be multi-door courthouse, and then the parties could either go to court or go to arbitration. And so we eventually decided that the only way to resolve it was to bifurcate the proceedings and have a hearing on jurisdiction alone. If I had no jurisdiction, that was the end of the matter. So first of all, parties had to pay to have a determination on jurisdiction. At the end of the day, my position was I had jurisdiction. The question was whether the claim was admissible at the time it had been filed. And so I postponed the proceedings for 45 days to enable the parties go through the mediation process. Well, they said they had mediated, but then they were supposed to go to some special form of conflict resolution. So I said, okay, I'll give you 30 days, go and do that. And if you are not, you cannot then mediate and settle, then come back to me and we'll continue with the arbitration. I understand that they didn't settle, but then opted to go to court rather than to come back to arbitration. But they incurred the costs and the delay in time. So it is very important to ensure that if you have a multi-tiered arbitration clause, that it is properly drafted, it is clearly drafted, and that parties understand what they are supposed to do and when. Thank you.
Thank you very much, Leonard. Thank you very much. Still on the subject of poorly drafted arbitration clauses or arbitration agreements. We often see copy-pasted or poorly drafted arbitration clauses. Dr. Ajibade, I'll come to you, sir. What is one clause defect that you repeatedly see that instantly creates a jurisdictional nightmare in arbitration?
Thank you, Harold. I mean, this is a nice segue from Mrs. Adekoya's intervention just now. The clause that I see that creates problems most regularly is any sort of ambiguity in relation to the manner in which the tribunal is to be appointed or composed. I think this is usually the first stumbling block, and I guess it's not surprising. For every litigator who has a bad case, of course, the first thing you're looking at is jurisdiction to see if there's a stumbling block there that you can throw at the other side. And once there's any ambiguity about the process, the manner in which the tribunal is to be composed, it just leaves the door wide open for that kind of guerrilla tactic to be deployed. So for me, it is extreme care in drafting the appointment provisions. And this problem can arise in so many different ways. I'm sure some of the distinguished participants here and maybe some of our colleagues who are listening will readily have their own war stories. But the one that comes to mind is a matter I was involved in a few years back, a multi-million-dollar dispute around the company that we all now know as Airtel. But then it was either Celtel or V-Mobile, or it's gone through a variety of name changes. But then a significant dispute had arisen between the shareholders, which had to be referred to arbitration. And the arbitration clause in the shareholders' agreement named the chief judge of the Federal High Court as the appointing authority, where parties couldn't agree. Of course, first prize in arbitration, based on party autonomy, is where the parties can agree on an arbitrator that they all have confidence in, or a tribunal that they all have confidence in. Or if it is an arbitral agreement that says one party appoints one, the other party appoints another, and then the two arbitrators jointly appoint a third. Now, as I said, the first prize is where that system works smoothly, but you must always anticipate the possibility that that system will not work smoothly. Indeed, there's a natural tendency in the arbitral community that no matter how distinguished an arbitrator is, once that arbitrator is proposed by one side, the other side automatically assumes that that person has been proposed because the party proposing him or her believes that he will be favorably disposed to their case. So the natural tendency is to reject that nomination, no matter how distinguished or how illustrious the arbitrator is. So in drafting arbitration clauses, I think it's always important to think through the process, think through if we agree, that's fine. Think through what happens if we don't agree, who then nominates. Ensure that nominating authority is properly identified. Again, I think in our case law, there's case law where somebody or where an arbitral agreement named the chairman of the Chartered Institute of Arbitrators, either Nigeria, I can't remember the exact language, but it turned out to be an office that did not exist. And the court had to go through all sorts of contortions to assist the parties to ensure that the arbitration wasn't stalled on that basis. So I think that it is making sure that the appointment process and the appointment procedure where parties cannot agree is set out as clearly as possible. The war story, the V-Mobile case, I think we must have been in court for upwards of maybe 5-6 years just on the appointment of the tribunal. We got nowhere near the merits. But there was a lot of back and forth to the Court of Appeal and back about whether it was the CJ of the Federal High Court, whether she had actually refused, and if she hadn't refused, what was the fallback position. It was a complete mess that gave arbitration, to my mind, a very bad name because, we spent so much time not dealing with the dispute, but dealing with the peripheral issues that could have been avoided if the arbitral clause had been better drafted.
Thank you very much, Doc. I will stay with you a little bit, please, just for, let me say, 1 more minute.
Sure.
What can go wrong in the very first notice of dispute or notice of arbitration?
Okay, again, this feeds
very briefly.
Yeah. No, this feeds off again from what I've just said. And this was, I think Mrs. Adekoya and I have a bit of a common war story on this one. It was within the last few years, maybe within the last 5 years, there was an arbitration in which we were both on the tribunal, and the party who commenced the arbitration, even though it was an ICC arbitration, purported to nominate. They had nominated arbitrators. Now, one thing we all need to be aware of is that arbitration is totally dependent on the rules you choose. And if you choose ICC or you choose ad hoc or you choose SIAC or you choose KIAC, you need to make sure you follow the procedure that is set out by the rules you have chosen. So this was an ICC arbitration. The starting point is that you register your claim with the ICC. Yes, you can nominate arbitrators, but you have to start at the ICC. But in this particular arbitration, the parties nominated one arbitrator, the other party nominated another arbitrator, and I was nominated, I think, as chair. And a proper objection was raised that this process, you haven't followed the process that is required in an ICC arbitration. So I think in commencing arbitration, it's important that attention is paid to what are the applicable rules. And again, going back to the question of assumptions, and not assume that all arbitrations or all arbitration rules or all arbitration institutions, that arbitrations can be commenced in the same manner. Each arbitral institution or each arbitration rule has its own peculiar process by which matters can be commenced. So if your notice of arbitration is not compliant with the process required by the rules you have chosen or by the institution you've chosen, then you started on a wrong footing right from the get-go.
Okay, thank you very much, Doc. Thank you very much, Doc. Hi, Chief Iheri. Let me come to you now again. What is the one thing every party should check before commencing arbitration proceedings?
Well, again, Mr. Moderator, thank you for the question. I am tempted to start off with the arbitration agreement, but that is a legal requirement. But before I go to the arbitration agreement, I want to start with something else, because whether we like it or not, when we are discussing these high-ticket arbitration cases that require resolution, they all border on taking commercial endeavors. And if you're going to undertake a commercial endeavor, it then behooves you, the claimant in particular, to ensure you have the necessary commercial war chest to be able to follow through and pursue these arbitration proceedings to its logical conclusion, i.e., to successful enforcement, should you succeed against the respondent. So I start off, I like to describe myself as a commercial person. And that's why you'll find in some climes, which I shall not mention, when certain disputes of a high commercial nature come to the fore for resolution, some institutions insist in the clause, arbitration clause, that they want these disputes resolved by commercial men. There's a reason for that. And it's to ensure that when that tribunal is eventually constituted, the tribunal consists of those who have the necessary commercial awareness to resolve that type of dispute. So I start off from the commercial point of view. Do we have the resources, the war chest, to follow this through to its logical conclusion? Then the legal angle starts off from what I said. I think I want to profile solutions here. Both Dr. Jibade and the distinguished lady Adekoya, sorry, Mrs. Adekoya, SAN, we've talked at length and discussed the problems with the arbitration agreement. First, the solution, if I may. What I suggest is that in-house counsel, when advising parties, should ensure that whoever is drafting the transactional documents, the agreement, the lease, whatever, they have the benefits of advice from and input from transactional lawyers who are well versed with the way the arbitration institutions deal with these disputes, so that when they insert a particular arbitration clause, and when they appoint, and when they mention a particular appointing authority to either supervise the arbitration, everyone is clear as to how the arbitration agreement is framed and drafted, how the appointment is likely to take place, so that there are no hiccups like the ones Dr. Jibade has described. That's the starting point, because just as Dr. Jibade has prescribed, if you don't check all of those, what you'll find when commencing the arbitration is that arbitration will run into roadblocks. What is roadblock? A jurisdictional challenge, either because of the way the arbitration is commenced or with the way the arbitrators have been appointed, and that derails the entire process. And while, yes, people begin to criticize arbitration as not being what it has been made out to be, but what has happened is the parties have not taken adequate care to ensure that the clauses have been properly drafted and the correct steps have been taken to constitute or institute the process and then constitute the panel of arbitrators. So this is something, it is not exciting, but it's something that parties must ensure that they do, in addition to ensuring that they have the commercial war chest to see the arbitration process through from inception to enforcement. Because really and truly, if you obtain that final award and you're unable to enforce that final award against the respondent who has assets or does not have any assets or is about to go bankrupt, then it's a fruitless exercise. So those are the things I would, and that's wearing my commercial hat as a tribunal member, I would enjoin parties to first check before, to take into account before commencing the arbitration. Then, of course, the other matters can follow, the arbitrators to appoint counsel to present the case before tribunals, and then the evidential considerations. The evidential considerations are crucial because in cross-border disputes, you'll find that evidential laws differ from jurisdiction to jurisdiction, whether you're engaged with a civil law background jurisdiction or a common law background jurisdiction, those differences will have an impact one way or the other on the evidence that you intend to present before the tribunal. I'll stop there for now, as to ensure that the other distinguished panelists have a say in this interesting topic. Thank you.
Thank you very much, High Chief. You have just brought us back to reality that if you want to, before you comment, you need to check yourself to be sure that you have more chest to proceed. Thank you very much, sir. I'm sure that's something that in-house counsel very much interested, because I mean, the feedback we always get is that we are the ones who spend the money. So we want to be very sure that we're ready for that. So let's go to the tribunal constitution now. Mr. Shobowale, let me come to you. What are the biggest mistakes that parties make when selecting arbitrators? Have you encountered a case where parties later regret their choice of arbitrator? Without mentioning names, please. Just
okay. Yeah. Thank you, Harold. So, I mean, they range from, I mean, a number of issues. I mean, I'll start with running a conflict checks, for example, right? Or doing a shoddy job of it. It's very important that, you know, you do your conflict checks carefully, not just about connection to any of the parties in the dispute, but also around perhaps any philosophical leanings of, you know, a potential arbitrator, right? I mean, you're in a commercial arbitration, and, you know, you have names of people who have socialist leanings, for example, right? And you've seen that in a number of awards they've given in the past. I mean, it's time to ask yourself whether, you know, they're suitable for the role that you want to assign to them. Now, another one that may not be so obvious is the penchant for going for what I will call celebratory arbitrators. They are trusted, they're experienced, they're respected, they're fair, they're balanced, but they're already overcommitted, and they cannot give your proceedings the share of mind that it requires to do the job well. Especially such arbitrators are the ones presiding. Then lastly, and this is one that I've experienced recently, is selecting a generalist arbitrator, an excellent one, right, where an industry specialist or a more commercial person, to use our chief expression, will do a better job. Or parachuting a global expert who does not understand local nuances of the market or the industry into an arbitration proceedings. Yes, they know the law, they have head knowledge, but there are certain things that, you know, they won't be paying attention to. So these are some of the things that, you know, I will recommend that we pay attention to in arbitrator selection. In the example that I just gave, I mean, clearly, there are certain Nigerian factors, you know, to use a common expression, that it's a bit difficult for a European to understand. And in those proceedings, it was very difficult to persuade a particular arbitrator about the behavior of, you know, certain committees of the National Assembly, because in his own understanding, he understands how parliamentarians behave in parliament when they are conducting proceedings, and he really couldn't understand how a lawmaker will cross the line into, you know, executive functions. And that caused quite a lot of delay. And we were really fortunate that the decision didn't go the wrong way as a result of this poor selection. So I'd like to stop here. Thank you.
Thank you, sir. Let me just ask a very brief follow-up question. You talked about running a conflict check. What is let's say, the biggest red flag that one should look out for when running a conflict check?
Okay. Obviously, association with any of the parties, right? Sometimes, as I mentioned before, philosophical leanings, right? You've read a number of awards by this arbitrator. You know that this arbitrator has a penchant for, certain views and so on and so forth. And therefore, even though they may not have a relationship with any of the parties in this arbitration, but they have a relationship with the issue that may then be impacted by, these philosophical positions that you can see from how they have determined previous arbitration. So those are some of the things that I'll look at. In Nigeria, if a wholly Nigerian arbitration, for example, I will go as far back as looking at where, the key parties went to school, right? And in which social party circles they move in. And all of that depends on, what's riding on the arbitration. Of course, sometimes this can be moderated by or by the fact that, okay, this arbitrator well. Yes, people should have social relationship and you trust them enough, not just personally, but also from history of the arbitrations that they have sat on, that they will not let those relationships interfere with their views. But the test for me is not even just about what you think, it's about the fact that if they are intimately connected in such a way that even if you understand that they are men and women of integrity, but other people will not understand, then it's probably better to walk away and look for somebody else. So those are some of the things that I'll consider.
Thank you. Okay, thank you very much, Mr. Shobowale. I have Dr. Jibade's hands up. I think you want to make an intervention. Please, very briefly, sir. Very briefly.
Yes, please. I will. I'll try and be as brief as possible. But one aspect of this question that intrigues me, and especially in our environment, is the fact that a lot of people, especially litigants and to some extent corporate counsel, think that the arbitrator, especially in a three-man panel, that the arbitrator is an auxiliary counsel to represent their position. And I think that's something that really is most unhelpful. Because, when I've been on the best three-man tribunals you have is where it's not even clear to any of the arbitrators who was appointed by who. Because you're all focused on the issues, not on defending a particular position. But when you have an arbitrator, if you appoint an arbitrator because you want that arbitrator to argue your cause, it becomes very clear very quickly. And rather than aiding your case, it tends to be counterproductive in my view, because the neutral arbitrator will realize what you're doing and will instinctively take a negative view of your case. So really, you shouldn't try to appoint an arbitrator as counsel. If you want to appoint counsel, appoint counsel. Appoint an arbitrator who is neutral and fair.
Thank you very much for that intervention. Thank you very much, sir. Let's move to evidential and procedural missteps. Dr. Jibade, I will come to you now. Most times, a party may have a very good legal case, but then documents tell a different story. What should parties be doing with their documents from the moment a dispute becomes likely?
I think this is, for corporate counsel, this is probably one of the greatest challenges. And I think Mr. Shobowale alluded to it earlier. Once there's a business relationship, really your document preservation strategies are essential. But I think it also touches on one of the things I said right at the beginning. It's also about the attention to detail. Because I've had experiences where, it's midway through an arbitration or even after an award that you now find documents that could either have aided you in making the case or in defending the case. And that is disastrous. And that is just a function of not paying sufficient attention to detail. And also, for the benefit of corporate counsel, one of the things I've also found is where counsel are intentionally withholding documents that they think may be adverse to their case. I view that as, you go to the doctor and you're not telling the doctor where exactly you're feeling the pain, and yet you want him to prescribe treatment. If I don't know what the weaknesses of your case are, there's no way I can anticipate and prepare to defend them. So when you have corporate counsel who are giving information to external counsel in a selective manner, trying to present the best case possible, oftentimes that falls flat on its face under, capable cross-examination, especially when you're hiding something that the other side may be aware of. And the worst thing for counsel is to be presenting a case and then to be met with a surprise. Are you aware of this document? You're looking at your client thinking, how come you didn't tell me? How come you didn't tell me about this document? So I think it is really, really critical that at the earliest stage, counsel engage with their clients. Corporate counsel also are forthright and put their entire case on the table and let the external counsel advise them. I mean, if a case is bad, a case is bad. You might be better off just settling the case rather than going through a hearing where you're still going to lose ultimately anyway. So I think when it comes to documents telling a different story, it's a real difficult space, and it's depending on what side of the dispute you're on, it usually is the juiciest part of a dispute resolution process. If you're the one that has a very good document that damages the other side, of course, it's a sweet spot. But you won't be tied if you're the one that's on the receiving end of a document that suddenly blows a hole in your case theory that you were never aware of until it was, until it came up in discovery or under cross-examination.
All right. Thank you very much, Doc. Mr. Shobowale, let me come to you. In today's world of email, WhatsApp messages, and electronic records, what mistakes are parties making with digital evidence, especially from your background as in-house counsel?
Okay, thank you, Harold. So those mistakes start long before you even have a dispute, right? And it goes back to how a company manages documents and information. For example, today, we do a lot of our work. I would probably say maybe 60, 70% of our work as in-house counsel by email. And we just, send these emails and, have a conversation back and forth and forget about it. Question is, when you have a dispute, do you have the means to retrieve these emails and put them together, especially if these emails were exchanged 3-4 years back? Today, in many corporations, after 3 months, sometimes 6 months, due to cost, you are not able to easily retrieve emails that you have exchanged with, in any transaction. And corporations need to start having policies around preservation of documents, and not just having the right policies, because one of the easiest things is to have policies, but adhering to the policies, auditing them, auditing discipline, adherence to those policies, auditing your investment in archiving documents and being able to retrieve them. Then when it comes to WhatsApp, now, WhatsApp, originally started as an informal means of communication, but today everybody uses WhatsApp. Even on boards, you have, boards that are in WhatsApp group, board committees in WhatsApp group, executive management in WhatsApp group. Sometimes when you even have a significant transaction, you create a WhatsApp group of all the parties involved, and you exchange these things. And without thinking around, okay, if I want to retrieve or get a record of those transactions, 6 months, those conversations, 6 months, 12 months down the line, would I be able to? What evidential value will be placed on WhatsApp? And in email communication, some organizations have rules around when you are sending corporate emails, make sure that you copy someone. Because, you may both have joined the company on a particular day, but no one can predict when you will leave. And sometimes when people leave organizations, even though they leave their laptops behind, the emails are backed up in the cloud, so-called. My experience has shown that that's easier said than done. To retrieve those documents, the investment that you need in time and mind share, working with IT to retrieve those things is quite significant. So my guidance is, I think as in-house counsel especially, we should recognize the limitation of the technology that we have, and we should adhere to first principles. When you're negotiating a contract, when you have gotten to a significant stage in those negotiations, back up your documents in a safe place. Don't leave them on emails, right? Second thing is ensure, and in-house counsels should take the lead on this, that you have robust document management policies. That not only should those policies exist, you should insist to your executive management that that adherence to those policies should be audited regularly. And of course, we should also advocate for the right kind of budget for proper modern document control and document archiving and retrieval. I think that all of those will serve you well when there is a dispute in future and you then need to recall this documentation. And I'll give an example as I close. I was involved in a recent proceeding where the negotiations were handled by someone very senior in the organization. And, very abruptly, the person left the position. And the question was, what was agreed with the counterparty? And it was really, really quite difficult to retrieve this information. Firstly, because the more senior you are, the more confidential your information is, even though they are corporate information. So they were not easily accessible even to the IT team. And the success or failure of this claim was going to ride on whether that document that we believe from looking at other documents exists could be retrieved. And it took about a month with the assistance of some technical expert that we had to hire at huge cost to locate those documents. And I dare say that when we located them, it shifted the dynamics of that arbitration proceedings. So in conclusion, I think that the investment we make in documents, archiving, document retrieval, disciplined adherence to communication, corporate communication ethos will serve us well when we have significant disputes in future.
Thank you very much, Mr. Shokomani. You have really expatiated on that. Mrs. Adekoyama, please let me come to you. We cannot overemphasize the importance of evidence in arbitral proceedings. Can one poorly prepared witness really destroy $1 million arbitration?
Simple answer, yes. And I will tell you why. Counsel who are less experienced in arbitration come into arbitration proceedings with a litigation mindset. And that litigation mindset, at least in some of the courts in Lagos, I don't want to go outside of Lagos, but my experience in Lagos has been that you have your writ of summons, you have your statement of claim, you have a witness statement, and the witness statement basically just replicates everything in the statement of claim. And in a situation where the opposing party starts to cross-examine the witness on things that are in the statement of claim that have been replicated in the witness statement that the witness has deposed to, has been his evidence, that he knows nothing about, cannot substantiate, refers to documents, and when those documents are presented to him, he wasn't a recipient of the document, he wasn't a sender of the document, he wasn't on the email trail for the document, and that goes to weaken the credibility of the witness. So going back to where we started from, which is, can you lose a claim before it even starts? Yes, you can, if you do not choose your witnesses carefully and do not get them to speak to the aspects of the dispute that they are conversant with. You may think you are saving costs by having the in-house counsel depose to all the facts in the points of claim, whereas the in-house counsel may have no relationship with the Treasury Department, where the issue that has resulted in the dispute has come up, has no personal experience. So when you're going to cross-examine, you are easily able to demolish that witness. So before you even start, go back and look at who your witnesses are supposed to be, how you are going to structure your points of claim and your evidence in support and the documentary evidence that's going to support it. Can one witness destroy? Oh, yes, yes.
Mrs. Adekoya, I'm afraid that your intervention has made me go back to a live arbitration my organization has, and it seems that we may be in some trouble. But thanks for this intervention. We have to go back and see how we can salvage the situation. Thank you. Thank you.
I hope you will compensate Mrs. Adekoya adequately for this intervention.
I will try my best. I will try my best. So, Prof,
yes.
let me come to you now. We often hear that parties lose claims because of procedural mistakes. Which procedural requirements do you think parties most frequently underestimate? And then, if you also have, just very briefly, if you can also still give a little of your experience on poor witness management too.
All right. I'll pitch my response for content and context for the benefit of in-house counsel. Now, when in-house counsel managing a large ticket dispute appoint external counsel to present or defend a claim before an arbitral tribunal, they must ensure that counsel in the firm who have conduct of that particular case attend two important procedural aspects of the arbitration process. One is the preliminary meeting, sometimes described as case management conference, and or the pre-hearing review meeting. What tends to happen is when you've appointed very eminent senior counsel to represent a party in these large ticket cases before a tribunal, they simply send junior counsel, pupils, to go and deal with the case management conference and the pre-hearing review meeting, to the detriment of the parties they represent. because what they've done simply is miss a golden opportunity for external counsel to understand how to present the case before the tribunal, how to interact with the tribunal to get the best results for the parties they represent, and how to comply with the procedural steps going forward to the eventual hearing or the issuance and publication of the final award. That's the main theme. The sub-theme under that heading is then, of course, most parties underestimate the importance of the potential to order for production of documents, disclosure of documents, then the presentation of experts' reports and expert witnesses, and of course, how to deal finally with the costs of the arbitration. And there are two aspects of the costs of the arbitration that comes to the fore, especially in international disputes where you have common law jurisdictions involved, like the United Kingdom and perhaps the United States. The potential for a claim to be made for security, for costs. Now, I find a lot of parties from different jurisdictions wrong-footed, find themselves wrong-footed, not knowing how to respond effectively to an application for security for costs. And because of that failure to address that issue, either at the case strategy stage or to envisage that that may come up, considering the jurisdiction from which the entities come from, then you find that some cases die a natural death there and then because of the inability to deal with questions such as security for costs. And that's a powerful tool for well-resourced entities coming from the first world, and when those applications are lodged and then parties don't have an answer to how to deal with those applications. And I have a few war stories about this. In a particular case where I was part of a tribunal that ordered security for costs against a particular Asian party, the Asian party now sued our tribunal to court and had accused my tribunal of being racist. That's because of the security for costs that had been ordered. Excuse me. And another war story I have to tell is in another case involving again some not Asian parties this time, but some West African parties. I shall not mention. Well, I had ordered disclosure of documents. The West African parties refused to comply with the order. At the pre-hearing review meeting, I simply made a comment that, well, I'm inclined to take a dim view of the failure of the party concerned to produce documents as ordered under a red fence schedule. That West African party went to the Federal High Court, sought an injunction to restrain my proceedings, the proceeding of my tribunal, and then accused me of being biased. Well, and that's again a way of covering up for the failure to anticipate that these are genuine applications that were likely to come to the fore. And that's because we had underestimated that these steps would be taken either for or against the respective positions they have taken. Something else they also underestimate is how to conduct a site visit, especially in construction cases. There's a protocol that ought to be followed, but most of the time, again, external counsel instructed by in-house counsel fail to deal with that adequately, thereby leaving gaps for mistakes to be made that might derail the strategy of the party they are representing. So these are all evidential matters that sometimes, and again, I think it's as a result of clash of legal cultures or a failure to understand where the other party is coming from, what they're likely to do in order to get, if you like, an advantage or progress their case forward before the arbitral tribunal. These are all matters that ought to be given adequate attention from the onset, and the failure to do that has grave consequences, and usually it would have grave consequences for the party concerned. So without repeating myself, I just want to highlight failure to pay adequate attention and to ensure that the right counsel attends the case management conference and the pre-hearing review meeting, and then failure to pay adequate attention to the importance of disclosure of documents and the selection of experts is crucial to be very, should I say, intentional in selecting expert witnesses that will present expert evidence in a manner that is structured towards assisting the tribunal to arrive at a decision that is fair and not structured in a manner just to favor the party's case. Otherwise, avoiding engaging experts that will act like hired guns. It's very important because the tribunal will take a view that, well, this expert is only coming here to tell us what his client wants to hear. And that is totally unhelpful and dissatisfactory from the point of view of the tribunal. So I'll stop there and see if my colleagues have anything else to contribute in this regard. Thank you very much.
Thank you very much, High Chief. Thank you, sir. To our participants, please, we have a poll that is up. Kindly take the time to respond to the poll. We have about 12 questions that we
Why is it?
Until our moderator joins back, I would like to interrogate some of the questions that the speakers have responded to. And I recall that before he went off, he had asked High Chief if he has any stories or if he could also share his experience about witnesses.
Right.
That there was any time in the course of your vast international arbitration experience that you've seen a really terrible witness that just killed the case for the party?
What I'll say is this. Yes, you find witnesses who don't add value to the case simply because they've been poorly prepared or simply because they don't understand what their role is, especially in technical cases. And what you find is that most of those witnesses, whatever evidence they provide, they do not know which will be attached to it. I mean, I'm struggling to think of any particular case at the moment, but what I can remember easily is expert witnesses who continue to act in a manner that clearly suggests that they've misunderstood what their duty is to the tribunal. And you will find such expert witnesses in technical cases simply skewing the evidence they have, their expert reports and the evidence to just satisfy what the point of view their client wants to put across to the tribunal. And when skilled counsel cross-examine them, you'll find those expert witnesses floundering so badly that you wonder why external counsel agreed for such experts to come before the tribunal only to make a mockery of the entire process of giving expert evidence before the tribunal. It's a painful thing to watch where you find skilled counsel cross-examining these experts who have not anticipated the extent of ferocious cross-examination, and particularly where you have a tribunal made up of, I was once serving on a tribunal with, where I had a chairman who was a consultant engineer, and it was a sorry sight to see the experts reduced to, if like, nothingness, because the evidence they were giving was not in conformity with what the technical member of the tribunal was aware of. And by the time the expert witness realized how far gone down the hill, it was too late for his own counsel to remedy the situation. So, and I think the lesson to be learned is for a general counsel to be very, just as they conduct the due diligence in the appointment of arbitrators, they should also conduct the necessary due diligence with expert witnesses and their expert reports. Let me just share one war story that has nothing whatsoever to do with me, but I think it's instructive for our discussions. Years ago, it was said, it came to my attention that a particular law professor in a particular West African country was appointed as an expert in what happened to be a contentious, high-profile family dispute, husband and wife family dispute that found its way to the High Court in the United Kingdom. I won't tell you which part of the United Kingdom. You will know that there are 4 parts of the United Kingdom. It could be England, Scotland,
Yes.
or Wales.
Oh,
thank you very much. But what is interesting for our discussion is that this particular law professor, who was also a senior counsel, had the rank of senior counsel. I didn't say SAN, so don't let anybody attack me.
You didn't say Queen's Counsel either.
I didn't say Queen's, but senior counsel. Now prepared the reports, very detailed academic expert reports, and included in the bottom of the reports that, look, my fees for this report will be 15% of any of the damages that the courts in the United Kingdom award to the party. And this expert report found its way into the courts in the United Kingdom.
Wow.
So now, all of us, how do you think that the courts will react to such an expert report?
Wow.
Regardless of the academic achievements of the law professor, and regardless of his eminence as senior counsel. I didn't say Queen's Counsel, I didn't say King's Counsel, and I did not say senior advocate. So,
just before I hand over back to the moderator, I will just share.
Yes.
And in this instance, I am sitting here as wearing the hat of in-house managing a dispute resolution, managing an arbitration. Yes. Ideally, we understand the principles of arbitration, that the experts are meant to assist the tribunal. But however, unless it's a tribunal-appointed expert, if I'm appointing you, the idea is that you support my case. In any case, you are not doing it for free. I'm going to be paying you. So anyhow you're going to do it, the expectation is that you argue and you support, and of course, and ideally you would review the experts' reports.
Okay, yes, indeed.
Can I jump in there?
And go finish. I will respond.
The experts' report. But the ideal thing, I know you are going to come back to the, but the ideal that this is from the point of view of parties.
Yes.
You are not going to appoint an expert that's going to say something that is contrary to your case.
I've not suggested that either.
Mm-hmm. So, and
can I jump in here and say that?
And I've handed over back to the moderator.
Okay.
Yes, ma'am.
I want to comment on 2 issues. The first is this question of whether experts are independent and whether they should be, because that itself could be the topic of a whole other webinar. But the point is that if you bring in, if both parties have experts, and you bring in an expert who is only going to support your case, and that expert, as has happened in a matter in which I was involved, if the tribunal gets the impression that the expert has taken a blinkered view and only supports the position of the party he's providing the expert report on, the credibility of that expert is damaged. And that doesn't help your case. The opportunity for the other side, having read the expert report and having got their own expert report, and now we go to procedural issues, to have been thoroughly briefed on the questions to ask your expert to show that he hasn't done his work, he's not taken account of various things, and those things he has not taken account of can have affected his decision. So my suggestion is, if you want to appoint an expert and the expert does not agree with what you want, listen to your expert. And this takes me back to another reason why we lose million-dollar cases before they start, is as to when you appoint the expert. Because really, you should appoint your expert before you file your claim.
Absolutely.
Or before
Absolutely.
you file your defense, so that you have that expert opinion. It may not yet be a report, but you have an expert opinion on your case ready at the time you're filing your report. You know where you're going. But getting an expert, if the expert refuses to agree with you, sack him. But if you get an expert who agrees with you, take note that you appointed one who didn't agree with you. It's not going to, it may not assist your case at all. The second issue I just wanted to comment on, just very briefly, was talking about procedural requirements. And one of the things that I think counsel, especially in-house counsel, in cooperation with their external counsel, overlook when preparing a case is document production. If you are coming from a litigation background, you come from the background of he who asserts must prove. And so as far as you are concerned, this is my case, this is the document that supports my case, end of story. Other side, the same. But arbitration is not like that, because document production allows you to request for documents from the other side that you think will support your own case or weaken their own case. And this is something that you need to take on board very, very carefully as to whether you want to use document production and the extent to which you are going to use it to support your case or to put holes in the case of the opposing party. Most counsel use document production looking for documents that will support their case that is in the hands of the other party. That's pure litigation strategy. But you can also look for documents that are in the hands of the other party that will weaken their case. And I think that's something as well that we need to take note of when we are preparing our matters. Thank you.
Thank you very much, Mrs. Adikoya, SAN. My apologies, I had some network glitches that threw me out. Thank you very much. Because we are pressed for time, I would urge us to move quite fast. Let's go on to settlement strategy and commercial reality. Mr. Shobowale, I'll come to you, sir. How do you know when it is time to stop fighting and start talking settlement or mediation in high-value disputes?
Okay, thank you, Harold. So the first thing is around cost. I imagine that in taking the decision whether to even activate a dispute resolution mechanism at all, you've done a cost-benefit analysis. So how much is at stake? How much is the value at risk? How much is it that you think you should be compensated for? And then versus how much do you estimate to cost you to get, an award? And in doing that cost benefit analysis, you have to be thorough. So you're looking at, the cost of the tribunal, advance on cost, you're looking at your counsel's cost, you're looking at the cost of expert witnesses, the whole gamut of things. So essentially, you've run the proceedings in your head and you have an estimate of how much it will cost. Now, estimates are estimates, right? And in dealing with lawyers representing you before the tribunal, you need to consider, well, in fact, you should in fact ask them for an estimate of how much they believe it will cost them to represent you from the beginning to the end. I imagine that part of the reasons why you are taking the final decision to file a request for arbitration is because the lawyers that you have selected agree with you that you have a case, right? And therefore, they have an idea of how much time they would devote to it. Of course, lawyers don't like cap fees, so they'll give you an estimate. And of course, estimates can be exceeded, depending on several factors that they will argue are not within their control. But one way to manage that is to say to them, can we have a capped fee? So you know how much it is we're claiming. So if I'm claiming $1 million, for example, you cannot say to me, well, if I have a team of, 10 lawyers and we work straight out for 2 years or whatever it is, and our fees is $5 million, then it is what it is, because then it doesn't make sense. So you agree with them or you persuade them to have a capped fee. Now, when you have all the numbers lined up, you then say to yourself, is it worth filing an arbitration for? And this is regardless of the fact that you were right, the fact that your counterparty has behaved unprofessionally or shoddily, or the fact that he was even dishonest. It's just a cost-benefit analysis. There's no point using good money to chase bad. So that's one consideration. Then when you start, now surprises do happen, right? Sometimes due to lack of, adequate preparation, your review of document, discovery, and all that can result in mounting costs, right? And then if the defendant, you're the ones who is claiming, defendant files a counterclaim, that also affects your cost. So when you have the number, so you know how much you're claiming, you have an estimate of how much you need to spend. When those numbers start, your cost starts to, exceed a certain amount, is one trigger to say, okay, let's reconsider. Of course, the other one is surprises. So you've made assumptions. One of the things that our panelists have counseled us not to do. You've made several assumptions about the strength of your case, assumptions about the ease of putting your case and evidence together and all that. And then you get midstream and you are finding out that it's very difficult to proceed. Or you find out that the time that the corporation is spending on that arbitration, some arbitration, literally nobody in the legal department is doing any other work. And at that point, you need to say, okay, look, we cannot run a business this way. And therefore, so we can't afford to continue with this arbitration because it's costing us too much money, it's costing us too much resources. It's likely, as we have found out, unfortunately, when we get midstream, that we're going to lose the case because we don't have evidence to support our case, or we have been poorly advised about the strength of our case. And let me close on the strength of, cases. So usually when you have $1 million arbitration, you expect that your in-house team will review the facts and come to a view that you have a good case and therefore you should proceed. But you also assume that because of the value at risk, you have external counsel also, doing that review. Many times what happens is because in-house counsel are busy with very many important things, we leave that work of review to the external counsel. Now, most external counsel are great people. They will give you a frank view and all that. But I've seen external counsel who, when your chances are probably 50-55%, overrate your chances. And because you haven't reviewed your case yourself, you are not able to challenge them about their conclusions. So when all of that comes together and you've gotten to a point where it's certain that you will lose because you don't have evidence, or you have been surprised in disclosures, or the cost of running the arbitration doesn't make sense versus what it is that you are claiming, or it is consuming time, or you don't have the technology to even, the documents exist somewhere. You've seen them before 4 years ago, but you can't just put them together. I think at that point, you should be able to say, here is when we should stop. And sometimes, if you are before a good panel, sometimes they give you or your counsel the hint, right? So sometimes, about how poor your case is, or their view about whether you are likely to succeed in establishing your claim. That, of course, presupposes that you can invest the time to be present at some of those areas, and which is a luxury that many in-house counsels do not have.
Thank you very much, Mr. Shobowale. We are pressed for time. Part of this webinar is to have a Q&A session. So before we get to the Q&A, let's just get some last thoughts from our distinguished panelists. In 30 seconds, please. In 30 seconds. Mrs. Adekoyama, can we just have your last words of advice to our panelists?
30 seconds. Preparation is key. You can lose your case before you file it if you are not fully on top of the facts. Because if you're fully on top of the facts, then you'll be able to decide what evidence is required to support the case. And you'll be able to determine whether or not that evidence exists, whether it is strong enough, and whether you should go forward. So preparation is key. Before you serve your notice of dispute, or before you file your points of claim, or before you file your points of defense, if you're a respondent. Preparation is key. You must know the case inside out.
In other words, Mark, there's nothing like being over-prepared for an arbitration.
No, there's no such thing. There's no such thing.
Thank you. Thank you very much, Mark. Dr. Ajibade, sir, can we have your final thoughts on this?
Yes, thank you, Harold. I think my final thoughts, I took a lot away from what Mr. Shobowale was saying about when you should decide to settle. And what comes to me really is that arbitration, unlike litigation, is not about conviction or fairness. It's not about, I'm doing this on point of principle. As we all know, arbitration is not cheap. You really don't want to go down the route of expending resources. As Mr. Shobowale eloquently put it, spending good money, chasing after bad. So I think for me, it's really, conviction is not what drives arbitration. It has to be cold-headed calculation, understanding the strengths or weakness of your position. And if you are not sure, then it's not worthwhile. If you're going to invest money, pay arbitrators, a panel of 3 perhaps. I know how much Mrs. Adekoya charges. I know how much Professor Heribe charges. You have to pay a tribunal of that of that expertise. If you're not sure about what you're doing, better
this is
not.
The marketing.
I said it.
Better be sure of what you're doing before you embark on it. That's my advice.
I guess this also goes to the beginning of drafting the arbitration clauses, because most parties they may not understand the cost implication of this. For instance, they may say three arbitrators when a single arbitrator could have solved this. Yes, thank you very much. Thank you very much, though. Mr. Shobowale, can we have your last final thoughts, please?
Okay. Well, I would say that every in-house counsel should consider 3 things before proceeding with an arbitration for a significant amount. You should do your cost-benefit analysis well. You should assess your ability to even recover even if when you are successful in getting an award. And the third thing is that you should look at the resources available to you in-house to support that process. $1 million arbitration is likely to require a lot of time to put documents together, sit in conference with external counsel, and just consider whether you have that resources vis-a-vis what is at stake before you proceed.
Thank you very much, Mr. Shobowale. Hi, Chief Sir. Can we have your final thoughts very briefly? Very briefly, your
Well,
final thoughts.
my final thoughts will be prefaced again with a commendation to the conveners of these events, and to encourage that more of these events are held between corporates and in-house counsel on the one hand, and external counsel on the other hand, who they intend to instruct or to represent their clients before arbitral tribunals. I think that this exercise, if repeated frequently enough, will improve the synergy between in-house counsel and corporate counsel to ensure better outcomes when their clients are represented before arbitral tribunals. And what that speaks to is ensuring that counsel whom they instruct, whom they decide to instruct, have benefited or have acquired the necessary awareness that goes with what transpires before various tribunals, various institutions, and various jurisdictions. I just want to commend this committee and encourage them to do this more often. And I can assure you of greater positive outcomes and results with your most favored $1 million disputes. Thank you very much.
Thank you very much, Hi Chief. Thank you very much. So the results of our poll is out. Let me quickly run through the results. The first question we asked, what is the biggest danger before $1 million arbitration begins? The majority, okay, I think there seems to be a little, okay. 75 out of 218 responses think it is poor strategy. 74 out of that number think it is procedural mistake. So there's a strong competition between poor strategy and procedural mistake. The second, at what stage do you think most $1 million arbitrations are actually lost? An overwhelming majority think it's at the contract drafting stage. Wow, that is interesting. That is interesting. The other question, when does your organization usually review the arbitration clause? 69% responded to say when drafting the contract. Yes. So we have the results of the poll. At this point, I will take some questions from the Q&A section. So we have a question from Shejil Ashraf. The question is as follows. Common law and civil law systems treat things like disclosure, interim relief, and interpretation of arbitration clause quite differently. When the contract law and the seats lex arbitri fall on opposite sides of that divide, what's the most common way you've seen that mismatch actually blow up a case? Well, this is a fully loaded question. It is not directed at any of the panelists, so maybe Hi Chief, if you could attempt this question.
Well, I listened to the question, and is a question that rears its head quite frequently. Again, is the clash between legal cultures, civil law, jurisdiction, and common law. And what to bear in mind is that the civil law practitioners are predominantly more inquisitorial, while common law tribunal members will be much more adversarial, meaning they will leave the parties to deal with the evidence to the best of their abilities. Now, for me, what I think something that's not been mentioned in our discussion so far is to recall that under some arbitral laws and rules, remember that those laws and rules empower the tribunal to disapply the strict rules of evidence. And I'm sure this will not come as a surprise to most of you who are litigation lawyers or litigators. But whether we like it or not, in some laws, I think it's even in the recent Nigerian Act. I know it's in the English Act. The tribunal is empowered to disapply the strict rules of evidence. Query, which rules of evidence depends on the evidence law in any particular jurisdiction. So what tends to happen for the gentleman who's asking that question, the tribunal will eventually come to terms in the deliberations as to the effect or otherwise of such evidence that may or may not have an impact on the dispute in question. And if the tribunal has a good chairperson who is conversant with both legal cultures, then of course there will be no difficulty in some degree of harmony being arrived at eventually. Surely the chairman of the tribunal will not allow such an evidential difference have a deleterious impact on the outcome of the arbitration. That's how best I can deal with that, with question from just listening to a bit of what has been said. But I'm sure my colleagues would have perhaps deeper insight or more contributions to make in that regard.
If I can jump in very briefly on that. To a large extent, the IBA rules on the taking of evidence has done a lot towards merging the concept of civil law and common law systems where evidence is involved.
Yes.
So if parties agree at the first procedural meeting that the tribunal may have recourse to, but is not bound by the IBA rules with respect to evidence, then for things like document production, where a civil lawyer sitting on a tribunal may be more amenable to granting broad document production, as opposed to a common lawyer who may have the mindset of he who asserts must prove. The IBA rules tend to bring people to the middle. And so there's a basis for that discussion. Where I see the problem occurring is possibly post-award, where a party believes that the decisions on document production have not given it a proper opportunity to put its case forward, and therefore now seeks to set aside an award based on that doctrinal mindset. You then be going to the law of the seat, who will then have to determine whether from the arbitral award and the decisions taken, the decisions as to documents that should be allowed in and those that should not, whether they have had any impact on the law of the seat. Thank you.
I'm sorry. Thank you, Mrs. Adekoya, for just reminding me of the IBA rules. Thank you very much. But in addition to that, is also the Prague rules, which may be of assistance in such circumstances.
And more civil law focused, but less popular.
Indeed.
I was also going to add to that to say that, this is one of the reasons why in international tribunals, especially a tribunal of 3, parties are well assisted if they have arbitrators from the different cultures on the tribunal, because they tend to balance each other out and arrive at the middle ground. I mean, one other area where there is clear difference between the civil law approach and common law is also in relation to cross-examination. Whilst the civil law culture is more focused on documents rather than on eliciting evidence through cross, the common law is really weighed towards testing the evidence through cross-examination. So tribunals tend to balance each other out and arrive at a middle ground. And I guess this goes also to selecting your tribunal, because depending on what nature of case you're seeking to present, especially if it's a sole arbitrator, you'd be well advised to focus on those nuances in determining who's the ideal arbitrator for your case.
Thank you very much, Dr. Jibade. Just one last question, and that is to Mr. Shobowale. So I would appeal that you answer it as within 30 seconds, please. This question is directed at you. How often did you get the cooperation of the board, the management/board of the bank, whenever you advise the management that the case of the bank is pretty bad and that it is better to settle rather than get the matter settled through arbitration?
So briefly, I mean, I think executive management and boards understand the concept of cost-benefit analysis and value at risk. So if you say to them, if we continue on this path, the lawyers will charge its fees, the tribunal will earn its fees, and we will be unsuccessful at the end of the day. And if we are not only going to lose money, we may also suffer some reputational damage. I think they will understand that. I think that it will cool their hurdle of, over my dead body, the other fellow should go to jail kind of thing, because they understand the concept of money and using good money to chase bad. So I think if you quantify it in commercial terms, I think it will be an easier conversation.
Thank you very much, sir. Thank you very much to amazing panelists. You have done justice within a very short time. I know that this is a very short time to deal with this. Thank you very much. I will hand over to the coordinator, Ms. Justina Lewa, to conclude.
Okay, thank you very much. I've been listening attentively. A lot has been said. So many issues brought to the fore, and how we in-house counsel should pay attention. So without delivering another lecture that will take us long, let me just highlight some of the key discussions, a takeaway that we would go home with. First, we should pay attention to details as it affects preparation for the arbitration. Review all documents. We should focus on all aspects of the claim. Do not focus on liability alone. And then we should identify critical building blocks of that case. We should know where the assets are. There's no point you are in arbitration and you don't know where the assets are in the jurisdiction. We should understand the dynamics of the case, and also be concerned on how best to resolve disputes in a cost and time-effective manner. Counsel who have a litigation mindset are working their way to total loss or partial loss. So in order to be able to understand our case, we should be able to be in control of our documents, manage the practices, and drafting of clear clauses, especially where it has to do with appointment, jurisdiction, and appointment and jurisdiction. There should not be any ambiguity, particularly in constitution of the panel. If there is, the ambiguity can be a guerrilla tactic for the other party to destroy your case. We also heard from the speakers that we should have a commercial watch list to check all that is required from us from inception to enforcement, so that you would be in control of your case. When an in-house counsel is drafting a clause, an arbitration clause in the agreement, we should please contact a transactional lawyer to review the clause so that it is clear to everyone and that is to deal also with the issue of appointment constitution of the arbitral tribunal. We should also run conflict checks. We should not appoint arbitrators that are like termed celebrities because they may not pay full attention to your case. So you should also not select an arbitrator that is not so knowledgeable in the area of your matter, because you will just have general knowledge, there will be no much in-depth knowledge. So that should guide us on the appointment of arbitrators.
Thank you.
Yeah, so I think that with that, there are so many other things that I have, but let me just leave it at that. I know that we also talked about digital evidence. We should back up our documents very well as in-house counsel, so that when you have matters, you'll be able to retrieve it, have policies in place. And yeah, let me leave it at that. So many other things we have said that I think that these are key issues. On the activities of the in-house, corporate and in-house committee, we have monthly webinars. This is just one for August. We've been having it from the beginning of the year. Now watch out for this, for the next one. In September, we will also come up with one. We also have video interviews where we showcase in-house counsel and the work that they do, and also share knowledge. So, and we know that sometimes we'll come to some of you here to help us with funding of those activities. When you do or organize beautiful webinars and videos, we don't just do it like that, we require funding. So when we come to you, please do not shy away from us. Gladly help us. Give us a little from your purse, from your $1 million.
Aha.
Yes, so, yes, hi Chief, and it is you. Okay. So me, I'm coming to you.
Ha.
Yes.
When Mr. Nikoya is there, and Dr. Jibade, and the banker emeritus is there.
No problem. I'm coming to you, hi Chief. So just get ready. When you hear me call you, don't say you are not there.
And this is unfair. Mr. Nikoya is there with 50 years experience.
No problem. It is you. I'm seeing all of them, but my thoughts is for you.
Okay.
So, okay. Yes. So we have our annual conference coming up in November. I will leave that to our chair, the delectable Mrs. Shola Adegbomire, will tell us more about it. So I will invite her now to give a vote of thanks and to conclude. Thank you very much.
Thank you.
Thank you.
Thank you very much. This has been amazing, really amazing. I needed to take some calls. I just could not step away for a minute. This has been really amazing. Thank you very much to all our truly esteemed panelists. I would love to say what I have learned, but Mrs. Lewa has already said everything. It's just been amazing. And, it's interesting. I'm happy Mrs. Lewa is here, because one of the reasons why we started this corporate and in-house counsel, I keep saying it was a conversation I had with her maybe like 10 years ago at the Pound conference, where she said, corporate counsel do not want to spend money on litigation or arbitration. That the business of corporate counsel is to see how little they can spend on litigation, on arbitration. That's when lawyers want to be on your list, that they are thinking of how little they will spend on all those things. And that got me thinking so many years ago that we really have to have a better liaison between corporate counsel, in-house counsel, and the whole ADR industry. And, we've heard so much today, especially from Mr. Shobowale, on how, look, if you think you have a bad case, I think there's a place in the Bible that says, settle with your adversary before he takes you to court and they collect everything you have. I mean, this has been really good. Thank you very much. Thank you, Mrs. Lewa. Thank you, Dr. Esson. Thank you to our great moderator. And thank you to all the panelists. And of course, at this time, at a point in time, we had about, when I checked, we had 509 participants on this webinar, 509 participants. I mean, it just tells you how wonderful this has been. Somebody just said highly inspiring. There are many adjectives we can use to describe this webinar. I just want to say thank you to everybody. Our annual conference comes up, and to all of you who have the million or $1 billion in your pocket, like Ms. Lewa said, come and knock at all your doors for sponsorship. The annual conference is in November. That is our flagship conference. It's the one conference that nobody should miss. People attend the conference from all over the world, and we're looking to receive all of you from Nigeria. On this webinar, there are people attending from all over the world. So I'm hoping that we will see all the different people coming from all over the world at the conference. I think that the early bird window for registration has been extended a bit. And so please, we invite you to not only attend, but also to support and sponsor the conference. It promises to be a very, very, very interesting conference. As always, all our conferences have been very interesting. This one too is going to be no less. So please keep the date in your diary. It's the first week in November. We're even looking forward to having the president of the CIAB Worldwide in attendance. Obasugbe SCN is the keynote speaker. And it's just going to be generally very interesting. Port Harcourt is getting ready for us, the Garden City, and they are really, really waiting. So please don't miss it. I will not, by the grace of God. And thank you very much for this wonderful, wonderful webinar. I've learned so much from all my big $1 billion arbitrators. Thank you once again. Yes. No hiding place. Even Mr. Esson in the in-house, no hiding place for you, sir.
Oh.
Yes, so
Banker emeritus.
Mr. Chesson Shobowale, no hiding place for you.
Right. Thank you very much. We've come to
Dr.
the end of
Esson, thank you for bringing all of them.
Thank you, ma'am. Thank you for all your support, and thank you for all accepting my invitation. Thank you, everybody.
Thank you very much.
Thank you very much. It's been a pleasure. Great pleasure to be here.
Thank you. Mr. Jibade, Mr.
Respect my call. Bye. Okay.
Thank you.
Bye. Thank you.